Krasinski.
The appellant's case...
Mr. Krasinski, I think you're sort of developing the invoice. Just before we move completely away from your pay, can I ask you one point about 26A, which has been puzzling me?
Yes.
Which is Primary Authorities Volume 1, Tab 8.
Yes.
And I'm afraid I don't have the MS.
Oh,
But
879.
879.
And what I wanted to ask was about the limitation aspect of this, which was explained to us by Mr. Thomas.
Yes.
That the claim to recover the input tax has to be made within, I think it's 6 months following the relevant date. And my question was, if the VAT is to be treated as being embedded in what was paid, or is treated as being due at the time of the supply, or fairly shortly thereafter, why wouldn't Zipvit be subject to the limitation period of 6 months from the earlier period? I mean, it's true they didn't know that they had the right to reclaim the input tax until we got the TNT decision. But on their theory of the case, as I understand it, they're saying actually they always had that right to reclaim. And the reason that I'm asking it, well, I appreciate it's more a point for Mr. Thomas, and so I'm raising it so he can...
Yes, no, I understand why the point might help my clients.
It helps. So it does help your client, but also I wondered whether it might have some bearing on the applicability of, in particular, the Volkswagen case, because I wonder whether it might be said that the position that Zipvit find themselves in is actually quite similar to the position Volkswagen was in, that Volkswagen was disabled from claiming the input tax because everyone had been making the false assumption that VAT was not due, whereas in fact it was. And Volkswagen was then wanting to make a late claim at a point when it was prevented by domestic law limitation from making the claim. And the reasoning of the Advocate General and the court was designed to show why they could make that late claim.
Yes.
But all on the basis, which you've already explained to us, I don't invite you to go back over that, of how the law operated.
Yes.
At all events, I just wondered whether you had anything to
Well,
say
about that. I don't want to say things without instructions on a particularly sensitive point like that. But for my part, I readily understand my Lord's question and don't dissent from the premises of it. All I would point out in relation to Section 26A 1A is that on our analysis, of course, Zipvit has never become entitled to a credit for input tax because it's never received a VAT invoice. And
No, I appreciate this. I should have made it clear. This is without prejudice to all the other arguments that you're presenting. But I was just trying to understand.
No, with respect, I see the force of my Lord's analysis.
All right. Let's leave that there.
Okay.
As I say, it's more of a point, perhaps, for Mr. Thomas.
Yes. As I understand Mr. Thomas's case on the invoice issue, it is that a taxpayer can always exercise his right to claim an input tax deduction, irrespective of any lack of invoice and irrespective of any defective invoice, subject only to two exceptions. The first being that there has been fraud or abuse, and the second being where the failure to comply with what is called sometimes the formal requirements means that conclusive evidence cannot be produced that the substantive requirements have been met. And while there may be some debate about what that second requirement actually means, he says it hasn't been satisfied in this case because, in effect, everybody knows, if we get to this stage of the analysis, that VAT is due or paid, and what the supplies were, and what the rate was. I'm not going to go through all the cases which Mr. Thomas took you to, leaving aside the time it would take to do that. It's not necessary. The fundamental difficulty for him is that not a single one of them, Ecotrade, SC Paper Consult, Dobre, IDEX, Cartrans or Vadan, addresses the very question with which we are now concerned, namely the need to satisfy subparagraphs 9 and 10 of Article 226 of the directive. Instead, I want to concentrate on just 3 decisions of the Court of Justice. Barlis, because a lot of analysis was given to that decision rightly by the Court of Appeal below. And also, for reasons that will now be obvious, the decisions in Volkswagen and Biosafe. Barlis was decided in September 2016. This was the case where the VAT invoices gave scant, perhaps no details at all, about the legal services that had been supplied by the lawyers to the recipient, who was then seeking an input tax deduction in relation to those services. Can I start, please, with the opinion of Advocate General Cockott? It's to be found not in, unfortunately, the primary authorities bundle, but in the additional supplementary authorities, the white-fronted cone-bound file, tab 1. Could I ask the Court to read, just by way of a preface, paragraphs 1 to 3 of the opinion? And then, please, picking it up at paragraphs 19 to 22, the referring tribunal seeks the answer to 2 separate questions. First, whether invoices such as those in the present case meet the requirements of Article 226 as regard the contents of the invoices, see A below. Second, to determine the consequences for the right of deduction if the particulars are inadequate, see B below. And then under paragraph 22, in the present case, the mandatory contents of the invoices are laid down in a binding and exhaustive manner by Article 226. The provision is applicable to invoices required to be issued by Article 220. The invoices had to be issued under 220 because the services were supplied to a taxable person. And then over the page, paragraph 30, the purpose of requiring a specific detail in an invoice depends, in turn, on the function an invoice has to fulfill in the scheme of VAT. As follows from recital 46, issuing invoices allows the tax authority of the member states to carry out their monitoring activities. Para 31. In light of this aim, the purpose of each individual detail in an invoice is directly connected with the question as to what the tax authorities ought to be able to monitor. First, monitoring payments of the correct tax. An invoice is intended first to enable a check on whether the person issuing the invoice has paid the tax. And that is a passage that is expressly endorsed by the court in its judgment. Can I just then invite you, please, to read the whole of paragraphs 33 and 34. And then after a reference to some other details required, for example, by Articles 2226, 2267, 2268, and 9 and 11, the court, I beg your pardon, the Advocate General says at paragraph 38, these additional details enable the tax authorities to monitor whether the person who issued the invoice has calculated the correct tax on his supply. On the basis of these details, the tax authorities can monitor in particular whether the person who issued the invoice ascertained the place of supply, the taxable amount, and the rate of tax in accordance with the law. And then, bottom of that page, there's a second monitoring function, paragraph 46. In addition, the invoice doesn't merely enable payment to the correct tax by the person who issued it to be monitored, as appears likewise from the legislative history of Article 226. It's intended to fulfil the function of proving its recipient's right to deduction. And again, that paragraph is endorsed by the court. The court's judgment is at Primary Authorities tab 20. Key passage is at paragraph 27, MS 901, internal 42. So para 27, MS 901, tab 20. As the Advocate General observes in points 30, 32 and 46 of her opinion, the objective of the details which must be shown in an invoice is to allow the tax authorities to monitor payments of the tax due and, if appropriate, the existence of the right to deduct VAT. It's in light of that objective that it should be examined whether invoices such as those in the main proceedings comply with those requirements of Article 2266. I'm not going to spend time on the rest of the judgment, which my learned friend, I think, took you to, at least in part, but nothing in the remaining passages concerns the requirements, we say the fundamental requirements, in Articles 2269 and in particular 10. The Court of Appeal dealt in significant detail with why, far from helping my learned friend, the judgment in Barlis exposed what Lord Justice Henderson called a fatal flaw in Zipvit's case. Again, in the interests of time, I won't take you to it now. It's paragraphs 112 to 116 of Lord Justice Henderson's judgment, with all of which we respectfully agree.
But I mean, before we leave Barlis, Mr. Thomas made the point that the court addresses two questions, as indeed did the Advocate General. One is compliance with Article 226, and the other is what's the effect if you don't have an invoice?
Yes.
Which complies.
Yes.
Do you want to say anything about the second part?
All I need to say, my lord, is that neither the Advocate General nor the court addresses what the consequences are of non-compliance with Article 226, 9 and 10. And as I'll show you, the same Advocate General took a completely different view in Volkswagen, I beg your pardon, in Biosafe, as to the effect of non-compliance with Article 226.10, which is our key requirement. So there's nothing that my learned friend can derive of assistance to our case, but I'll take you to that in a moment. Can I then deal with Volkswagen and Biosafe and make the important chronological point that they both post-date every single one of the invoice cases which my learned friend took you to. Volkswagen is at Primary Authorities tab 20, beg your pardon, 36. I'm not going to take you back to the facts of the case. And the conclusion you've already seen. Just briefly to pick it up, MS 1162, paragraph 43, it follows from the foregoing that, as the Advocate General observed at point 58 of his opinion, him being Advocate General Campos Sanchez Bordona, that although under Article 167 the right to deduct arises at the same time as the tax being chargeable, Article 178 provides that it can be exercised only once the taxable person holds an invoice. So that's a general proposition cited by the court there. And then we've already seen the conclusion in paragraphs 49 and 50, and I've already taken you to particularly the words in the opening sentence of paragraph 50, only following that adjustment, i.e. once the adjustment had been made, the VAT had been paid to the state and an invoice had been issued, that the substantive and formal conditions giving rights to arise to deduct VAT were met, and Volkswagen could therefore request to be relieved of the VAT burden due or paid. But again, that conclusion is entirely inconsistent with Mr. Thomas's submission, because in this case, in other words, in Volkswagen, as in the present case, there was no dispute that the supplies had been made by Hellas to Volkswagen. There was no dispute who the supplier was, what the nature of the supplies was, and what the rate of VAT was. If Mr. Thomas was right, the court would have said that in those circumstances, both the substantive right to deduct arose and the formal right to exercise it arose at the time of the supply, irrespective of non-compliance with the formality of having had a correct invoice showing the VAT at the time. And the position becomes even clearer in the decision and the opinion of Advocate General Cocotte in Biosafe. Can we start, please, at the Advocate General's opinion, tab 21 in the primary authorities bundle. I've already taken you to the key passages at 44 to 48 of the Advocate General's opinion, which are at MS 916, and I'm not going to go back to them. So I took you to 44 to 48. I'm now going to pick it up at 49, top of MS 917, internal page 58. Where she says as follows: I would therefore submit, in concert to this extent with the view expressed by the Commission.
I'm so sorry, which paragraph?
49.
49.
Top of MS 917.
Yeah.
I therefore submit, in concert to this extent with the view expressed by the Commission, that it also follows from the principle of neutrality that the right to deduct input VAT in a given amount arises only to the extent of the VAT amount payable that must be shown on the invoice pursuant to Article 226.10 of the directive. The special significance of 226.10 as compared with the other formal requirements is also apparent from Article 203, that's the one I've shown court already. The feature that must be present in order for the recipient of the supply to be able to deduct input VAT, quote, the amount payable, triggers a statutory liability, tax liability solely by virtue of being indicated on an invoice. I think I said to my Lord Briggs that Advocate General Cocotte had said something precisely the same as what you put to me, and this is where she says it. And then paragraph 54 over the page. The fundamental principle of the neutrality of VAT requires deduction of input VAT to be allowed if the substantive requirements are satisfied, even if the taxable persons have failed to comply with some formal conditions. That's the formula repeated every time. It's always some formal conditions. Consequently, where the tax authorities have the information necessary to establish that the substantive requirements have been satisfied, they can't, in relation to the right of the taxable person to deduct, impose additional conditions which may have the effect of rendering that right ineffective. The court concludes from this that the tax authority can't refuse the right to deduct VAT on the sole ground that an invoice doesn't satisfy the conditions in 226.6 and 7 if they have available all the information to ascertain whether the substantive conditions for that right are satisfied. Footnote 28, Barlis. This might support the inference that input VAT is deductible even without any invoice at all. At the end of the day, after all, an invoice is only a formal condition. Where it is objectively satisfied that the substantive conditions laid down in Article 168 are satisfied, a failure to comply with the formal conditions might not be a bar to the deduction of input VAT. However, that inference is precluded, not least by the clear wording of Article 178A. In the case law cited, moreover, the court expressly laid down as a further condition of the right to deduct that account be taken of a corrected invoice. See some of the case law that's in the bundle. Consequently, neither that case law nor the VAT directive supports the inference of a right to deduct without possession of an invoice. All that remains unclear is whether an invoice, in this case from 2008, which shows too little or no VAT, that's Zipvit's case, can be regarded as an incorrect invoice within the meaning of the case law. If so, an invoice could in some cases be retrospectively corrected on account of a purely formal error, meaning that the deduction of input VAT too could or would have to be claimed retrospectively. In that regard, it must be pointed out that the court's decisions on retrospective correction of invoices have essentially been concerned with a situation very different from those of the present case. In those cases, the right of deduction had arisen in principle, and there was agreement between the supplier and the recipient of the supply in relation to the amount deductible too. On receiving the invoice, the recipient of the supply therefore knew in what amount he would sustain a charge to VAT and in what amount he was entitled to obtain relief. What's more, he sustained the charge to VAT no later than at the point when he paid the formally incorrect invoices. In those situations, the invoices were lacking only a number of details which didn't, for that matter, have any bearing on the amount of tax owed by the supplier or the amount of the charge to tax sustained by the recipient. It seems inappropriate to me to infer from that case law that the amount of input tax deduction to which the right in principle has arisen may also be amended retrospectively. As the court itself emphasised in Senatex, the particular feature of that case was that Senatex held invoices at the time of exercising its right to deduct VAT and had paid input VAT. It's noted here, in its case law, the court has, for the benefit of the recipient of a supply, who concurs with the VAT shown on the invoice, paid that VAT and therefore sustained it as a charge, allowed formal errors in the invoice to be retrospectively corrected on the grounds of proportionality. The absence of any indication of the VAT amount or the indication of a VAT amount too low is however quite different from a missing VAT identification number, an incorrect date, or an inaccurate description of the goods or services. These details are material only to the monitoring of transactions by the tax authority. The VAT amount shown on the invoice, on the other hand, is material to the amount of the charge sustained by the recipient of the supply and therefore to the amount of relief sought by means of an input tax deduction. Unlike most of the other invoice details prescribed by Article 226, Article 226.10 is therefore not a purely formal condition of input tax deduction. Rather, that detail is essential to ensuring parity between the charge to tax and the deduction of input tax by the recipient. A retrospective amendment of the VAT amount payable cannot therefore have retroactive effect within the meaning of the aforementioned case law. Consequently, an increase of VAT not previously charged, that is to say, not entered on an invoice, is not merely the correction of a formal error. Rather, it's comparable with the initial issue of an invoice. For here too, the supplier indicates for the first time the amount of additional VAT he's passing on. The recipient of the supply likewise discovers for the first time the extent of the additional charge to VAT on the relevant transaction which he would sustain if he paid the later invoice. With respect to Advocate General Cott, we agree with all of that. Now, the point that will be made by Mr. Thomas is that the court's judgment does not expressly adopt all of that analysis. And Lord Justice Henderson, in the Court of Appeal, noted that this was an interesting discussion, but he didn't need to decide whether it was right because the invoice appeal failed for more fundamental bases that he had already identified. Nonetheless, as with the Volkswagen case, the court's decision that I've already shown you is entirely inconsistent with Mr. Thomas's case that his client can have a right to deduct input tax in the absence of an invoice showing the VAT amount payable as required by Article 226.10. And whether you call that a formal requirement or a substantive requirement doesn't matter. Whatever the adjective, both Volkswagen and Biosafe in the court's decisions show that the requirement has to be met. That's what I want to say on the invoice issue. Can I just, in the remaining 2 or 3 minutes, answer my Lord Sales's question about legitimate expectation? Can I make clear, it's no part of my job as counsel for Her Majesty's Revenue and Customs to make life easy for people who may subsequently seek to rely upon legitimate expectations against HMRC or other public authorities. However, in fairness, I need to point out that there may be an answer to my Lord's question about European law and ultra vires in the fact of Elmica itself. Can we possibly go back to that? It's Additional Authorities, Volume 1, tab 28. Can I just start, please, with MS 1335, bottom of the page, internal 158. I'm afraid the paragraph numbers themselves are somewhat obscure.
Yes.
But it's the bottom paragraph. And what this paragraph does is identify the nature of the representation. In a letter to the State Financial Service for Shipping, i.e. the Piraeus Tax Authority, Elmica asked whether, in relation to the provisioning by its tanker on behalf of Oceanic, the vessels sailing on foreign voyages and transporting fuel from refineries located along the roadstead on the port of Piraeus, it had a legal obligation to charge VAT on the bill of lading, or if it was exempted, and if so, under what procedure. In response to this request, so here comes the representation, the Piraeus Tax Authority stated that the bills of lading were exempted from VAT. So that's the analogue to the revenue in our case, saying postal supplies are exempt. Then, paragraph 8 underneath that. Following the abolition with effect from January 93, and January 93 predated the representation which was made, as we saw, in June 94. Following the abolition of the VAT exemption in respect of supplies of services for the transport of petrol products, the services supplied to Elmica became subject to VAT, and explains why that is. And in those circumstances, the competent tax authority charged Elmica by way of 3 decisions, and there was then a challenge to that charge, with Elmica saying, hold on a second, I've been told that they were exempt. Picking it up then, please, at MS 1343, beg your pardon, 1342, internal 165, paragraph 26. In its third question, the referring court asks, in essence, whether under the rules and principles of community law on VAT, conduct of the National Tax Authority authorising a taxable person not to pass on the VAT to the other party to a contract can, even if that conduct is unlawful, so ex hypothesi unlawful as a matter of EU law, give rise to a legitimate expectation on the part of the taxable person that would preclude subsequent payment of the tax. And then, please, paragraph 32 over the page, I've already shown you. As regards the principle of protections of legitimate expectations, it's appropriate first to determine whether the conduct of the public authority gave rise to a reasonable expectation in the mind of a reasonably prudent economic agent. Paragraph 33, in the present case, as set out in the orders for reference, Elmica asked the Piraeus Tax Authority the question. So there was a debate about whether Elmica had asked the right tax authority. And in Greece, so my learned junior tells me, there are certain designated tax authorities that have the competence to answer certain questions. So there didn't appear to be any, although the question is formulated in paragraph 26 on the basis, can you generate a legitimate expectation even where that is of unlawful conduct? That doesn't seem to trouble the court. The argument was about, could they reasonably rely upon a promise by one tax authority when it may not have been the competent tax authority to give that promise? And the answer then, at paragraph 33 on MS 1345. In that respect, it falls to the national court to decide whether Elmica, which operates a tanker to carry petrol products within Greece, could reasonably have believed that the tax authority of Piraeus was competent to rule upon the application. And then they continue at paragraph 36. They say national tax authorities are obliged to respect the principle of protection of legitimate expectations. They don't say, and by the way, if you created a legitimate expectation contrary to what the VAT directive, or then the 6th VAT directive, you should have done, that is somehow unlawful.
Yes. But I mean, that just demonstrates that the principle of legitimate expectation operates in a different way in EU law, precisely because you can have an unlawful representation which founds a legitimate expectation.
Yes.
I mean, over the short adjournment, I had a very quick look at Professor Tridermas's book on
Yes.
principles of EU law.
Yes.
And it seems that under EU law, you go through a different reasoning process of looking to see to what extent enforcement of the expectation would undermine important principles of law and interfere with the EU legal order before deciding that you will give effect to it.
Yes, well,
We're,
it may be that
we're not invited to do that. We haven't been shown the authorities
No.
that show us the exercise. So
No.
I think the point remains that we have exiguous information about the EU law doctrine of legitimate
I think that's, with respect to fair characterisation of the position, but as I've already submitted, we don't suggest you have to go that far in this case for the reasons I've already explained, and the burden being on the appellant, if he was going to say there was some legal basis upon which HMRC should have assessed, it was for him to bring a JR. Those are our submissions.
Thank you very much. Ms. Mitrofanos?
No, my lord.
Thank you.
Oh, yes.
Mr. Thomas.
Could I, as an initial point, draw your attention to a couple of articles of the directive that I have handed up, had printed off. I'll come back to them, but they in my submission are the right provisions to be looking at, rather than Article 203 when deciding on whether or not a person has a liability to make a payment under the directive. It's Article 199 in particular. And I'll explain how they fit together when I reach that part of my submissions.
Did you say Article 199?
Sorry. 193.
193.
193. And the distinction between 193 and 203 is 193 is the one that applies to taxable persons fundamentally, and 203 is the one that applies to anybody. And 203, as I will explain, is there in order to catch fraudsters. But the actual provision that you rely on in order to impose a liability of tax on a trader is 193. And all that you require for that is that the person be a person making a supply of services, not issuing invoices. Now, I want to deal first very quickly with a specific proposition that my learned friend put to you yesterday. His fifth proposition was that Zipvit's appeal throughout these proceedings has assumed that no further sum is due to be paid to Royal Mail. Now, it is right to say that Zipvit believed when it first brought these proceedings and believed all the way to the Court of Appeal on the basis of the documents to which it had access, that the contracts with Royal Mail were silent as to VAT, as a result of which we say that the VAT would already have been included in the sum paid on the basis it was inclusive of VAT, and that we say that's uncontroversial tulica. It was only following a request by the Court of Appeal to the commissioners to contact the Royal Mail that the commissioners revealed that they had since 9th of July 2009 been holding evidence to the contrary, and one sees that in a letter written by Mr. Emanuel of the commissioners to the Court of Appeal, which is at page 761 of the electronic bundle. And in the course of that letter to the commissioners,
And I'm
We'll
sorry,
see
Mr.
little-
Thomas, I rather...
sorry,
going to
I
the
do apologise. It's appendix
part
part 2, page 519.
Thanks.
I do apologise.
No, not so.
Further, an email has been located from Royal Mail to HMRC dated 9th July 2009, setting out clauses from an access contract and from the Royal Mail general terms, stating that charges are exclusive of VAT. The Royal Mail general terms were expressly stated to apply to a number of services, including mail media. So on the face of it, looking at that document, as early as that date, there would appear to have been information available to the commissioners as to the liability to charge of the mail media services. And that was a date which predated the first claim made by Zipvit on the 15th of September 2009. So we say this wasn't a case of the commissioners not having the information. They had it already. Zipvit did not. Now, following those revelations in the decision of the Court of Appeal, Zipvit's position has been that it accepts that Royal Mail could have demanded more, subject to whatever the outcome of the limitation point might be. But one can understand why it was that Zipvit was willing to ask for an invoice in those circumstances, because it thought that the only sum to which it was ever liable to pay was the sum which it had already paid. That might have been wrong, but it does substantially depart from my learned friend's arguments in relation to what Zipvit's position was in this particular case. And none of the documents that were available to Zipvit, and it had and were made available to the first-tier tribunal, said anything about VAT. As one can see, the reference is paragraph 11 of the first-tier tribunal's decision, which is at 194 of the electronic bundle, tab 8, page 192 of the core bundle.
But Zipvit signed up for the services on the basis of terms and conditions.
Oh, it did. It did. And
So when you say not available,
it didn't have them. It certainly didn't have them. And I suspect it was one of these cases where most of these transactions were undertaken electronically rather than physically, so one didn't actually get to see all the documents at the time one was signing up.
I'm sorry to interrupt, but I'd like to point one thing out that you may have already spotted, but I've only just spotted. The letter at tab 50 appears to have been a draft, because there's lots of things saying Sam to confirm this and Sam to look
Yes,
at
I do appreciate that.
So on the face of it, it's a privileged draft. I don't know how on earth it came to be in the bundle. The actual letter sent, just for your record, is at the next tab.
Page.
MS 763, internal 520. So I just don't know, I can't explain how that privileged letter came to be in the bundle.
Well, I don't intend to get into disputes about whether or not the waiver of privilege. I do hope that in these circumstances the commissioners are not trying to suggest that what was said at that paragraph is wrong.
Which paragraph?
Little 2 on page 761. So that's all I want to say about that particular proposition. Now, my learned friend's submissions on Articles 73, 78 and Tulica, they say Tulica is at page 957, tab 25 of the primary authority is page 98. Their case is what was said by the Court of Justice in paragraph 37 undermines my case on the VAT being part of the consideration. The situation is otherwise where the supplier has the possibility under national law of adding to the agreed price a supplement equal to the VAT applicable to the transaction and recovering it from the purchaser of the good. Well, one has to ask, when is this likely to be? What happens in such a case, and what is the result? Now, it might be that what the court was referring to is because there is some statutory power in national legislation to allow someone to charge a supplement equal to the VAT to a purchaser, even though the agreed price doesn't mention that. That would, as I said in opening, equate to Section 89 of the VAT Act. Well, if that is all the court meant, then it is a very limited scenario and it adds very little. Alternatively, the reference to the possibility under national law might be a reference to contractual provisions in accordance with national law. Well, if it is so, it's an odd way of putting it, but let's assume for the moment that it is. In those circumstances, we have to need to know what is meant by the supplier having the right to add a supplement to the agreed price. Now, the contract might say, for example, the price is £100, but if the supply proves taxable, the customer agrees to pay a supplement equal to the VAT. That, when properly understood, is an agreement to increase the recoverable consideration from £100 to £120. A supplement to an agreed price is, in my submission, a description of the price, the amount of which is contingent on whether or not VAT is chargeable. But it's all consideration.
But, I mean, isn't it fairly clear what they are saying? The supplement is equal to the tax applicable.
Oh, absolutely.
So-
But you're allowed to increase your price. It's not saying that you get the VAT back. It's not talking about the VAT being recovered and only recovered in those circumstances. It's increasing consideration by a specified quantified amount.
Right.
It may be that parties to a contract will refer to the price being X pounds plus VAT. But the aggregate is a contractual consideration. And as Lord Briggs said this morning, one's got to read Articles 73 and 78 together in order to understand precisely what those are doing. And they are doing precisely the same as, in my respectful submission, I described Section 19.2 doing yesterday. One must always distinguish quantification from fiscal analysis. Now, if I move to my learned friend's due or paid arguments, they start with T-Mobile. And at the heart of the Commissioner's case is a very short passage from T-Mobile at page 1106, which is tab 33 of the primary authorities, page 247. From the opinion of Advocate General Cocotte in T-Mobile. That wasn't endorsed, wasn't referred to by the Advocate General, of course. But if one travels up from 145 to the start of the passage, the paragraphs, the group of paragraphs, one sees the question which is being asked. Is the frequency use payment to be considered a gross or net figure? That's all that's being asked. It's a quantification question. Now, both the first-tier tribunal and the upper tribunal consider that the quotation was taken entirely out of context, and the references are paragraphs 84 to 91 of the first-tier tribunal's decision. Electronic Bundle 316, Appendix Part 1, Tab 5, page 74. Now, I'm sorry, I haven't used the core bundle index. It's in tab 8 as well. And also, Mrs. Justice Proudman, sitting in the upper tribunal, page 295 of the electronic bundle, addresses the argument at paragraphs 45 and the first sentence of paragraph 46. And the hard copy reference for that is Appendix Part 1, tab 4, page 53. They can be found in tab 8 of the core bundle as well, but they're also there. The Court of Appeal didn't bother to consider the case. And I say that therefore T-Mobile is really not a fruitful place for my learned friends to seek support for their argument that the parties themselves can agree whether or not the price received, the payment which was made, rather than the consideration, included a VAT element. All that Advocate General Cocotte was doing at that stage was looking to see what the overall price of the transaction was. Now, if I can move on to my learned friend's brief arguments on Mason and Boscawen, Simpson and Marwick. My learned friend took you back to paragraph 52, I think it was.
Page. Sorry,
I'm apologies. My computer is letting me down and I haven't actually.
don't worry, I've got it now.
Yeah. Mason Boscorn, it's most of the way through, isn't it? So come back down. It's page 21552156.
Which paragraph?
It's paragraphs 52, I think.
1027.
Yes, that's got it.
It's 1027
Yeah.
in the electronic.
It is in one. Thank you. And the only comment my learned friend made was, well, when you look at little 2, what the learned judge is saying, I'm struggling with my computer. Have you got a hard copy? Is that the prima facie rule under VAT is that some agreed for suppliers is inclusive of VAT. Well, yes, but prima facie really doesn't assist here. The question is, once one has identified the consideration for the supply, how much of that is VAT? And the learned judge's conclusion is that you always start with the consideration and work back from that, because that's what section 19.2 requires you to do. Now, my learned friend addressed you on section 36 in relation to Simpson and Marwick, but he seems to have misunderstood my arguments. I never said that section 36 was engaged here. It is section 26 capital A which is engaged. And for that reason, I say his submission misses the point. In this particular case, we now know that an amount of 100 out of £120 was paid. And once no more than that has been charged, section 26A and article 90 engage to say, work out your VAT from the amount which has been paid. That is it. And I'm sure I'm going to...
Well, this may be the appropriate point for me to ask you my question about section 26A. Because on your submissions, I mean, that's been true since the time of the supply.
Yes.
Even before TNT came along and told you that that was the true position. So why don't Zipvit fall foul of the 4-month limitation period for claiming the input tax?
There isn't a 6-month period for claiming input tax. There's a 6-month period after which you may not claim any more input tax than that in respect of which payment has been made.
As I understand it, the 6 months puts a cut-off.
Yes.
After which the payments actually made become the price.
Yeah. If one starts from
You
the
can't claim
proposition that
tax
one
on a
doesn't
greater
actually have to
price.
pay the price before one claims one's input tax.
But it's something to do with when you can claim the deduction.
But if you've claimed your deduction, you may not have paid the price, so you don't know at that stage. But the first 6 months are the period in which you then get to pay your price. And then at the end of the 6-month period, you look to see how much has been paid. And the answer to that question dictates the amount of VAT you may deduct. So if in this particular case, Zipvit, realising that the total price was 120 rather than 100, had claimed 20, then at the end of the 6-month period, only having paid 100, the effect of section 26A is you've got to pay £3.34p back to HMRC because your entitlement is only £16.66, because that which is paid is composed partly of VAT and partly of basic price. That's the function of 26A, and that's why it conforms with Article 90.
Thank you.
Now, my learned friend took you to the ITC case, which is in the second supplemental bundle. And as I understood it, he was addressing the operation of ITC in relation to an example which he said was set out in paragraph 65 of the respondent's case. But when I looked at the respondent's case, the example really didn't seem to have much to do with with ITC because it was a case where a supply had been treated, as I think, as exempt and then proved to be standard rated, whereas my learned friend was trying to suggest, well, what if, like this case, something had been treated as standard rated but actually turned out to be exempt? Wouldn't one in those circumstances, if you were, I suppose, Zipvit, be able to say to the customer, sorry, would the supplier then be able to say to the customer, well, you thought it was all exempt, you thought it was £120 which you were paying for an exempt supply, therefore you can keep the totality of the sum. Well, again, I don't detract from the general view that in determining how much consideration and what the nature of the consideration is, you look at the contract between the parties and you look at to see whether or not on a proper construction of the interpretation of the contract between the parties, the sum of £120 was actually paid as being, I'm paying you £100 plus another £20 contingent on it being standard rated, or I was going to pay you £120 in any event. Now, when one reaches that stage, one drives up against Mr. Justice Mann's implied terms in the RM Glow case. And there one has to ask oneself, we don't have anything express in this contract. The contract is silent, it just says £120. In those circumstances, taking into account the full matrix of fact on which we were the parties happy to treat everything as being £120 because it was exempt? Or should there be an implied terms that it should be treated as £100 plus £20 VAT, which was only payable in the event that VAT was payable? Or should we, in another circumstance of a similar nature, if treated as £120 plus VAT on top in the event that VAT proves to be charged? Nothing in ITC really answers the question that we have to deal with here, because the question we have to deal with here is looking at a very different case where that which was paid is consideration. If that is the only consideration that is ever paid, but it is a standard rated supply, then Article 90 and Section 26A and Section 36, if necessary, engage. And they dictate the amount of VAT which is then payable in relation to the transaction by reference to the consideration which actually was payable under the contract, and by reference to the consideration which has been paid under the contract. And if there is a difference between the first sum, namely the sum which is payable under the contract, and the second sum, the sum which is paid under the contract, then the VAT adjustment provisions operate in accordance with that outcome. And when at paragraph 5 of ITC, Lord Reed says the customer's liability to pay an amount in respect of the tax rests in contract, that is simply going to quantification again. It doesn't enable my learned friends to run an argument that this means that if the parties don't agree that the customer should pay VAT, then that which the customer has paid must not be treated as including VAT. My Lord, I can deal very quickly with MDDP and VDP Dental Laboratory to the extent that my learned friends continue to rely on it, and simply say that that is a rule which applies and has only ever been applied in relation to a case where a supplier whose supplies are under European law standard rated has taken advantage of a domestic failure to treat the supplier standard rated, but instead deemed the supplier to be exempt and not charge VAT on that supply, thereby enabling him better to be able to participate in the market. If in those circumstances, at a later stage, when it proves that the supply is standard rated, he seeks to recover his input tax, it is reasonably said in those circumstances that that supplier must take both the burden and the benefit of his own supplies. He only gets the benefit of the inputs to him if he treats his outputs as standard rated. In our case, Zipvit wishes to take advantage of its supplies to it being standard rated, and it has accounted for every penny that it was asked to account for on its own supplies, all of which were standard rated. Now I can pick up my learned friend's arguments in relation to Volkswagen and BioSafe. And it's worth remembering what Lord Justice Henderson said at paragraphs 78 to 80, which was that he said that neither case threw any useful light on the due or paid issue because it wasn't an issue that the Court of Justice was addressing. But the reason that that was so was when one looks at what the case was concerned with, each of them was concerned with the extension of time limits, where it proved at a late stage that the VAT characterisation placed on the transactions by the parties was misconceived. And one can see that most easily in BioSafe, page 906. Paragraphs 20 to 23. Which sets out the facts, and little d Flex refused to pay the excess on the basis of the time to claim an input tax deduction had expired. So that was the fundamental. And Advocate General Cocotte issued the opinion which advanced the proposition that the right to deduct input tax in a given objectively correct amount arises only on receipt of a VAT invoice. That's page 917. Paragraph 52. It's page 58 of the primary authority bundle, my lord. And says that the directive precludes legislation under which the time for deducting the additional VAT starts to run as soon as the original invoice is issued. One might ask what an objectively correct amount is, and what happens if one in fact discovers it is incorrect, and what happens if the supplier decides not to collect any further consideration from the customer. Well, those are all questions which are not answered by the Court of Justice, whereas in that particular case, BioSafe was clearly in time to bring proceedings against Flex, and did so. But the question one asks and has to ask here is, how does that particular analysis interact with Article 90 of the directive? Article 90 wasn't in play in BioSafe because the additional sum was still available to be demanded. So the case doesn't really address those issues which arise in relation to Tulica and Article 90, which was why Lord Justice Henderson had difficulty considering that the cases really answered the questions which are before this court. Now, the Advocate General also said in a number of different places most specifically at paragraph 65, that the existence of an invoice showing the VAT due was not only a formal condition, but a substantive condition of deducting input tax. But that's not a proposition which was accepted by the Court of Justice, as one can see at page 907, paragraph 32, where the court repeats the classic formulation that there are detailed rules in Article 178 onwards, which may be considered formal requirements or conditions.
Sorry, which page are you on now?
That's 907,
Thank you.
and that is
Yeah.
I'm not sure whether my learned friend can.
48.
48, sorry, I've
Page
got it already.
48. Thank you so much. So then at paragraph 42, the court goes on and deals with the problem before it by drawing attention to the objective impossibility of Flex exercising its right to deduct. And it gives two reasons why that is so. It seems that it was objectively impossible for Flex to exercise its right to deduct for the VAT adjustment carried out by BioSafe, since beforehand it did not possess the documents rectifying the initial invoices and did not know that additional VAT was due. Now, pausing there, why did the court think it necessary? What was the point of mentioning an absence of knowledge that VAT was due if the court had been of the opinion that the absence of a VAT invoice was sufficient in itself to deny the taxpayer the right to deduct? Then at paragraph 43, it does indeed say that it was only following the adjustment that the substantive and formal conditions giving rise to a right to deduct were met. And it goes on that in the absence of a lack of due diligence or failing any fraud, a period which started to run from the date of the initial invoices and for which certain transactions expired before this adjustment could not validly be used to deny Flex the exercise of its right to deduct. So in my submission, what the court is doing at that stage is to temper the running of the domestic limitation period when there is a combination of the two elements mentioned in paragraph 42, the invoice and the knowledge, because it was objectively impossible, having regard to a combination of those two things, for the taxable person to exercise its right to deduct. Now, if, of course, the recipient had held the amended invoice at an earlier time, it would have had objective knowledge that VAT was payable, because the invoice would have said so. If, by contrast, it had known that the additional consideration was payable, it would have had actual knowledge that a claim could be made, even though it wouldn't have had an invoice. And in either case, the court seems to imply, time could have run because the recipient could have made a valid input tax claim. There is nothing in the decision to say that what Zipvit did was wrong, and indeed the court goes on to say that the taxpayer must exercise due diligence if it is to be within time limits to bring a claim. And failure to make a claim timelessly might well be a reason to deprive one of the right to deduct, even though one cannot extract a VAT invoice from one supplier, because, as we now know, one has no right, no enforceable right, to enforce that statutory duty. And the court may remember that Advocate General Tanchev, in the Vadan case, to which my learned friend did not refer, dealt with and distinguished Volkswagen and BioSafe as both being cases concerned with delay and the need for diligence. The reference is at Electronic Bundle 1136, paragraphs 83 and 84, tab 34, page 277. Now, a similar thesis to her views in Biosafe runs through Advocate General Cocotte's opinion in Barlis, which is Supplementary Bundle Tab 1, the second supplementary, the white supplementary bundle. And if one just looks at, very quickly, page 15 of the Advocate General's opinion, that's page 15 of the bundle, one sees the summary of her opinion set out at paragraph 102. And her answer 4 is, in accordance with Article 178A, it is in principle not sufficient for the exercise of the right of deduction. The recipient of an invoice who seeks to exercise that right supplements the details missing from an invoice, contrary to 6 and 7, by other information, unless that other information consists of documents which are themselves to be regarded as part of the invoice. None of that appears in the Court of Justice's conclusion. One goes to page 902, paragraphs 43 to 46 and 49, wherein Barlis.
I have it, Mr. Thomas.
You have it. Oh, I'm so grateful, my lord.
Which was the paragraph?
It's 43 to 46 and 49. One looks at what is required in those circumstances. 45, in the dispute is therefore for the referring tribunal to take into account all the information provided in the invoices in issue and in the annexes produced by Barlis in order to ascertain whether the substantive conditions have been satisfied. And at 44, the authorities cannot restrict themselves to examining the invoice. They must also take account of additional information provided by the taxable person. And at 49, then it follows from the above considerations that Article 178 must be interpreted as precluding the national tax authorities refusing the right to deduct solely because the taxable person doesn't hold an invoice, where even though those authorities have available all the necessary information. So it's not the hard black letter approach adopted by the Advocate General. We're not having to elevate all this back into an invoice. It's enough that there is supplemental information.
But that does seem, in paragraph 49, to focus specifically on subparagraph 6 and 7.
Oh, absolutely. But of course, that's the question which is being asked before the court. Mm. It's not because that's the necessary conclusion that only 6 and 7 are therefore in some other form. Now, it is right to say that the Court of Justice, in paragraph 43 of Volkswagen, which is at page 1162, which is Primary Authorities, tab 36, page 303, my lord. Does say it follows from the foregoing that, as the Advocate General observed at paragraph 58 of his opinion, that Article 178 provides it can only be exercised once the taxable person holds an invoice. But again, that was in the context, I say, of tempering the application of domestic limitation rules. And since then, the Court of Justice has confirmed in Vadan that in the absence of an invoice, it suffices that the taxpayer holds conclusive objective evidence that the substantive conditions giving rise to the right to deduct have been satisfied. And it's worth noting the authority on which the Court of Justice in Volkswagen relies for the proposition in paragraph 43 is Senatex. And Senatex, the relevant reference is at page 1663. I don't propose to take you there, but it says that it's an in principle it follows that the right to deduct must in principle be exercised in the respect of the period during which the right has arisen and the taxable person is in possession of an invoice. And the qualification is in principle, which indicates in my submission there may be other cases where that principle may be displaced. And those cases, I say, are legion and include authorities such as Verdun and Barlis and so on, IDEX, Dobre, Eco-Trade, none of which requires the relevant taxpayer to hold a tax invoice before he's entitled to make the deduction. So there becomes a need to reconcile the cases, and perhaps it comes to nothing more than this, that when dealing with time limit cases, the Court of Justice is willing to offer accommodation to a taxpayer who does not yet hold a taxable invoice, and is willing to suspend the time running until he does, because the fiscal authority is not in a position to prove that at an earlier date the taxpayer held the necessary alternative evidence, which would have afforded a satisfactory degree of proof sufficient to start time running. Albeit that the Court of Justice in BioSafe did emphasise the need for due diligence on the part of the taxpayer, which did suggest that there may be circumstances in which such proof would deny you your right to deduct in the absence of an invoice. But in other cases where the taxpayer ventures to make a claim without an invoice, the court is willing to entertain that claim, provided the right quality of alternative evidence is forthcoming. But even then, the court is alive to the risk of imposing formalities, an excessive burden on the claimant by the formalities required by member states before such alternative evidence is admitted, provided, the court says, the substantive conditions have been satisfied, the formalities, whether domestic or European, must give way. You could, in certain circumstances, do what the Advocate General does in Volkswagen and Barlis and call the further information that is provided part of the invoice. But certainly in Verdun, the court says nothing of the sort. And it also appears, from my learned friend's argument this morning, that they rely on these cases as authority for the proposition that where the parties consider that a payment which is being made does not include VAT, the amount of VAT is not included. Now, that proposition, as I say, was not accepted by the Court of Appeal. And it is a proposition which, if my learned friend rightly said, he obtains from the opinion of the Advocate General in the various cases and not from what the Court of Justice did. And it is, in my respectful submission, unwise in those circumstances to conclude that the Court of Justice did indeed adopt the passages on which my learned friend has relied. And in fact, if one looks at the Volkswagen case and the question answered by the court, one sees that the court ducked that very issue. If one goes to page 1161, tab 36, page 302, paragraph 32, one sees the questions which are asked by the referring court. And the first question it asks is in two sentences, the second sentence of which is, in other words, is it possible for a taxable person who has not been charged VAT on an invoice to claim a tax refund? And what the Court of Justice does is to recast the question. It doesn't answer that question, which is the question that the Advocate General answers. You go on to paragraph 33, you see it says, by the first four questions, which it's appropriate to examine together, the referring court asks in essence whether EU law must be interpreted as precluding legislation of a member state under which, in circumstances such as those in issue, in which VAT was charged to the taxable person paid by it several years after delivery of the goods in question, the benefit of a right to a refund of VAT is denied on the ground the limitation period provided for by that regulation for exercise of the right began to run with the date of supply and expired before the application for refund was submitted. Nothing about whether the VAT could be seen as being embedded in the circumstances where no further payment is ever made. As I say, the court just simply doesn't address Article 90. And if one goes to page 1172, in Volkswagen, the opinion of Mr. Advocate General Sanchez Bordona, one sees at paragraph 58 the passage which the court did indeed endorse, specifically in its decision. But then at 59 onwards, there is a considerable exegesis which moves on at 63 to 65 to explain why things happen in the way they do, none of which is adopted by the Court of Justice at all. And as I say, what the Court of Justice does is to adopt a standard approach to the recovery of VAT, subject to a degree of generosity in relation to a time limit case. And as I indicated in opening, the failure to adopt the view of the Advocate General is then confirmed in my respectful submission by the later decision of Vadan, where there is clearly a willingness expressed on the part of the Court of Justice to entertain a claim for input tax recovery without any invoice at all, provided that there is an adequate quality of alternative evidence. If one then, and I'm sorry to jump about here, but if one then goes to page 916, back into the opinion of Mrs. Cocotte in BioSafe, which is tab 21. Thank you so much. It's paragraphs 46 to 47, which my learned friend says, well, those were very important, highly material to the Advocate General's opinion. In my submission, if the Court of Justice had wished to endorse it, it would have done so. And it isn't sufficient to say, well, had they not wished to do so, they would have expressly wished to depart from it. But there is no reference to paragraphs 40 to 50, 44 to 50 of the opinion in the Court of Justice's opinion in BioSafe. All of which are provisions which eventually lead up, as I say, to paragraph 65, where the Advocate General elevates the holding of VAT invoice into a substantive condition. Now, whilst I'm here, I'll deal with Article 203 in my learned friend's submissions, that's the time at which the debt is created. And in my respectful submission, that is not the way in which the legislation works, either in the directive or indeed under domestic law. If one looks at the directive and the additional provisions I provided you with, Article 193 as I say, is a provision which engages where you have a taxable person carrying on a taxable supply of goods or services. The liability to pay is created by Article 193. And Article 203, which doesn't require the person to be a taxable person, is there to sweep up cases of fraud. It's a very specific provision which captures fraudsters who issue a VAT invoice purportedly for a supply in order to be able to claim additional consideration from their customer. In circumstances like that, having mentioned it, you have a liability to pay it.
Advocate General Kokot, I think it was her opinion in BioSafe, seemed to attach more significance.
She did, and I simply don't understand why she did so, because, and I can't put my finger on it at the moment, there is in fact a decision of the Court of Justice which my recollection is suggests that the Article 203 only engages in those very exceptional circumstances.
Yes, thank you.
But if one can see the point in the UK legislation, one looks at section...
Article 193 comes under the heading obligation to pay and persons liable for payment of VAT. I mean, it doesn't...
As does Article 203.
Are they all under the same
They
heading?
are.
The section.
Because as you see, Section 2 starts at Article 206.
Yes. I see, thank you.
And of course, it's just the same as I showed you yesterday in relation to Section 1(2) of the VAT Act. A person is liable to pay when he has made a taxable supply. There's nothing in the UK legislation which says you've got to issue an invoice before you have a liability. VAT on any supply of goods or services is a liability of the person making the supply and becomes due at the time of the supply. That is why all my learned friends' arguments in relation to debt and enforceability and so on drop away in my submission. And one picks that up in the collection procedures, which is Regulation 2, which is in the light blue supplementary bundle. Tab 4, page 13. Any person required to make a return shall pay to the controller such amount of VAT as is payable by him in respect of the period to which the return relates, not later than the last day on which he is required to make that return. So that's when the liability to tax accrues. It's nothing to do with assessments or issuing no invoices or making voluntary disclosures or anything of the sort of which Judge Mosdale mentioned in her decision, to which my learned friend looked. It is simply a question of a liability which accrues as a result of the supply being made.
Which regulation were you referring to?
Regulation 40, sub-reg 2, which is
42. I have it, thank you.
Yes.
Thank you very much.
Sorry, can you just give me a page number?
Page 13.
Page?
13 of the supplementary.
Oh, supplementary. Yeah, okay.
Tab 4, page 13.
Yeah.
Thank you.
I wonder how that works, though, where a mistake has been made. I mean, it looks as though Regulation 40 sub 2, the obligation to pay runs with your obligation to pay the return. So if you've made a mistake and your return doesn't show VAT due,
Well, you haven't discharged, you still have a liability, but you haven't discharged it.
right?
What the assessment is the means of enforcing or recovering the debt. It's not the moment at which the debt is created. Now, if I move on to the supplier as collecting agent, the problem is, in this particular case, the commissioners have not collected their tax from the Royal Mail. They may have reasons for doing so. We can't say whether those reasons are meritorious or not. And the matter is, we say nothing to do with Zipvit. We say you cannot expect Zipvit to suffer because the commissioners have reasons not to pursue Royal Mail. And I rely again on Elida Gibbs' paragraph 33, which says merely because you can't collect the full amount of tax from the supplier doesn't mean that the amount of input tax recoverable by his customer is diminished. Vele Claire, which is at page 1138, tab 35, is of no assistance to the commissioners. At the time when these supplies were made, and at the time when the claims were made, we say Zipvit had a contractual obligation to pay consideration to Royal Mail. We now know how much that was. That liability has been discharged in part, and at the relevant time, the rest remained due. Royal Mail may not have sent a further demand for that at the relevant time, but it was open to the commissioners to assess Royal Mail, and it was open to Royal Mail to raise a VAT invoice on Zipvit. So the commissioner's position is, well, we've so hamstrung ourselves that we felt unable to recover the VAT from Royal Mail. And that means that no tax is due from Zipvit to Royal Mail, and no consideration is due from Zipvit to Royal Mail, and Zipvit may not therefore have an input tax deduction. I say there is no authority for that, and Vele Claire comes nowhere near to establishing that proposition. I say that this counts as one of those cases where the substantive conditions which have to be satisfied for the purposes of deducting input tax under Article 168 have all been satisfied. And the commissioners are seeking to undermine the fundamental right of a taxpayer to recover his input tax. Cases such as Bonnick make it perfectly clear that where, in fact, the commissioners are seeking to undermine that right on some basis, the burden of proof falls on them. They never pleaded at any stage before the tribunal that if the supplier were liable under domestic law, nevertheless the commissioners would not have been entitled to recover that tax from Royal Mail, so that it was unenforceable. Their argument before the tribunal, as my learned friend explained this morning, was that Mar leasing did not apply to Group 3. But we now know that it did. The first-tier tribunal decided that, and it wasn't appealed. So they never laid the groundwork for the proposition which, in my submission, would have been required and for which they would have been obliged to provide the evidence in support of the reasons why they had not sought to recover the tax from Royal Mail. I'll come back to the document to which they took this morning, but I say that takes them nowhere. Vele Claire itself is a very limited case. It concerns the liability of the same person both for output tax and input tax in relation to the same transaction, which was an importation of goods into the EU. And assuming Vele Claire to have been a fully taxable person, the two items matched, and there would then have been only a need properly to report the matter to the tax authorities. But Vele Claire, as matters transpired, without having paid the output tax to the commissioners, sought to recover the input tax. And the first of the two decisions of the court was that merely because Vallée-Claire had not paid output tax to the tax authorities did not mean it could not recover input tax. And that's paragraph 27, I think, of the decision of the Court of Justice. But be that as it may, if my learned friend doesn't like Bonnick as a proposition for saying that you may recover your input tax without proof that the tax has been paid, Vallée-Claire is just such an authority. Secondly, there arose the question whether a deduction should be allowed when the tax authorities had no hope of recovering the output tax because the claimant was undergoing an insolvency process and they had proved too late in the insolvency process. And if one turns to the Court of Justice's decision, page 1154, tab 35, page 295. Paragraph 17, and one looks at the question which is being asked. By its question, the referring court asks in essence whether Article 17.2b of the directive is to be interpreted as allowing a member state to make the right to deduct VAT on importation conditional upon the actual prior payment of that tax by the taxable person, where the taxable person is also the holder of the right to deduct. So that's the limited scope of the question which is being asked in Vallée-Claire. The Court of Justice was dealing with Article 168E, which was a successor to Article 17.2b, and not with Article 168A. And the enforceable tax claim with which the court was therefore concerned was that owed by the claimant to the state and not to the supplier of the goods. And that's why it was the state's claim for tax which lay at the heart of the case. Now, of course, that's readily discernible in a two-party case, state and importer. But how is it supposed to function in a three-party case? How is the customer to know that assurances have been given by the commissioners, lawfully or unlawfully, to the supplier that they won't seek to collect the tax from him come what may? But if such assurances have been given so that a public right claim arises, says HMRC, that is sufficient to deprive the taxpayer of his right to deduct input tax. And all the way through Vallée-Claire, the approach to the claim to tax is couched in terms of VAT on importation. The only questionable passage is at paragraph 19 on page 1154, which just below the passage we were just looking at, where there is a single reference. Thus, the wording of that provision, which repeats the expression used in Article 17.2a of the directive, according which taxable persons or paid in respect of goods supplied, clearly provides the taxable person's right to deduct concerns not only that which he has paid, but also VAT which is due, that is which is still to be paid. It's narrative. It is difficult, in my respectful submission, to discern from that the conclusion that the court reaches in relation to a two-party taxpayer-state transaction is the same as should be applied in a three-party transaction when one's not looking at the liability, as my learned friends say, of the customer to pay the supplier, but one is looking at the liability of the supplier to pay the state. Which then brings me to the European authorities on which my learned friend relies in support of his argument that there can be a legitimate expectation created by the state. which would entitle a taxpayer not to pay his tax. The first of those is El Mico, which is in Primary Authorities, tab 28, page 1310 of the electronic bundle. The relevant passage is at 1354. Paragraph 32. What I would invite you to focus on is the fact-finding exercise which is supposed to be undertaken by the domestic court in order to see whether a legitimate expectation has been established. It requires conduct of an investigation into whether the conduct of the administrative authorities gave rise to a reasonable expectation in the mind of a reasonably prudent economic agent. And apart from the bare statement in the notice to which the Commission has referred you this morning, there was and is no evidence of any kind as to whether the Royal Mail ever considered the notice. And one must also bear in mind in my submission the timing of the supplies which are the subject matter of the claim here, some of which fell before the actual decision of TNT, but some of which fell afterwards. The second case that my learned friend relies on is the Salome case, which is at tab 44 of the second authority bundle, I think, second additional authority. Page 1462 of the electronic bundle. Page 465 in your bundle, my lord.
Thank you.
And the passage that my learned friend did not draw your attention to this morning was paragraph 47.
Which is the electronic page, sorry?
1642? 1642, I'm instructed.
42. Thank you.
47.
47. In particular, although it was disputed during the hearing by the Romanian government, the fact that in 2010 the national tax authorities not paid property transactions such as those in issue in the main proceedings subject to VAT in a systematic manner does not in principle suffice, except in very specific circumstances, to give rise, in the mind of a prudent and well-informed trader, to a reasonable expectation that tax would not be levied on such transactions. Taking into account not only the clarity and foreseeability of the applicable national law, I confess it's not so clear taken by itself, but also the fact that the present case appears to involve professionals from the property sector. Here we are dealing with the ultimate professional in the mail sector, the Royal Mail, a state entity which must have been deeply concerned as to the appropriateness of the tax position. At the very latest, once the Advocate General's opinion in the Danish postal case had been published, and when it became aware that the Commission were investigating and in fact bringing infraction proceedings against member states for failing properly to apply Article 1321A,
Does this court need to go into any of this?
I sincerely hope not.
Because I mean, it's an agreed fact in the Statement of Facts and Issues that at the time when the supplies were made, Royal Mail and Zipvit considered the services to be exempt. And where would they have got that understanding from, but from legislation and something that was said by HMRC?
With the greatest respect, that doesn't necessarily follow, my lord. The Royal Mail, as so many
Not
other
necessarily,
institutions,
but
would take its own legal advice. The Royal Mail has a very significant number of eminent lawyers, all of whom would have been focusing very carefully on that very particular
and what would they
issue.
go to? They would go to the statute and they would go to any guidance that HMRC provided. What else would they be looking at?
Well, the guidance I would not have thought was a notice which was issued to general traders of the sort that we have here. And there may have been discussions, but we don't know what the discussions were. But what we do know is that following the decision of the Advocate General's opinion in 2003, Royal Mail incorporated within its provisions, we can't say earlier, there were earlier cases when it didn't, but certainly from 2003 onwards, we know that they incorporated a provision which said postal supplies are exclusive of VAT. If they were so confident that they did not have to worry about the collection of the tax from HMRC, why did they include that general term and condition? In my submission, they were very concerned. There's no evidence whatsoever that, in fact, they sought assurances or received assurances that HMRC would not collect this tax.
What possible basis do we have for going behind the first sentence in paragraph 8 of the Statement of Facts and Issues, page 59?
In my submission, that doesn't take us all the way. It still leaves the question. That may have been the conclusion they drew, but the question is whether they drew that conclusion as a result of assurances given to them by HMRC, which is a different question. A couple of other points to clear up on. The first is my learned friend's other hypotheses. All I would say of that is bear in mind that not all Royal Mail's trade customers were fully taxable traders. And therefore it would certainly follow that in negotiations between such customers and Royal Mail as to what should happen in the event that VAT was chargeable, there might well have been reasons not, in fact, to allow the Royal Mail to negotiate that the VAT should be added on top. Competitive reasons might well have restricted the Royal Mail to charging no more than it did charge. We simply don't know. So one would need to consider the full context of negotiations between the relevant parties in any particular contract to decide what the right outcome was. Those, I think, address all the submissions that my learned friend made, and unless your lordship, my lady, have any further questions, I would invite you to allow the appeal.
Could I just ask, given the exchanges concerning Volkswagen and BioSafe, among others, your position is that the authorities are act clear in your favour. But if they're not, then you'd be asking for a reference.
Yes.
I perhaps better clarify with the revenue what their position is.
Yes.
Well, it won't come as a surprise to hear that our position is that the authorities are act clear in our favour.
So is it the mirror image that if the court were unwise enough to disagree with you, then you would want the reference?
I have to be careful what I say on behalf of the government at this time, as the court will appreciate. Can I answer the question by dodging it? And answer, my lord, by saying that this court still has the power, post-Brexit Day tomorrow, to refer a case to the Court of Justice.
Until December the 31st.
Till December the 31st. We will, in accordance, unless we're being told we don't need to anymore, we will be providing the court with a note. The truth is we'll be doing the drafting, I'm sure. Mr. Thomas will be happy to look at it.
Isn't the position that today, and I'm not sure what it is tomorrow, it's not just a power, it's a duty if the matter is not act clear. Now, is that changed during the during the completion period?
That is the position that we are tracing through in the note. So my lord is completely right that A, that you will carry on having the power to refer, and B, that up until tomorrow, as the final court of appeal of this country, if you consider a matter not to be at clear, you have a duty to refer. We will clarify in the note, tracing through the relevant provisions of the treaties, the 2018 Withdrawal Act and the 2020 Withdrawal Act, whether that obligation still applies between Brexit Day and the end of this year.
Because if it does, it's not a question of what the parties want.
Yes, that's correct.
Yeah, I just wanted to know what your position was on the subject, and you're ducking it in the interim until we get this note.
Yes.
So in your note, if it's just a power, not an obligation, will you be saying what your position is, whether you are asking us to make a reference
because
or not,
of the political
and what your submissions
sensitivity, can I just turn round and there's been a lot of thought overnight to this whole question, you won't be surprised to hear. Can I just take some instructions for a moment?
Just as well I asked.
Yeah, quite. Does our internal acting with the duty it does? It's the power. I think so. They don't deal with power versus duty.
If the position transpires to be that in the interim period between now and the end of the year, you no longer have a duty but only have a power, we will give a view about whether you should or should not exercise that power.
Okay.
Well, that's very clear. Thank you.
Thank you.
Well, it only remains for me to thank Council.
Sorry, one other question on timing. The note we've already begun work on the note. It requires a degree of cross-departmental consultation in whatever DEXEU has now become. I think it's about to be conflated with Cabinet Office again. Can we have until the end of next week to provide my lord and my lady with the note?
Having cleared it with...
Yes, I would hope to get it to my learned friend by Thursday or Friday morning. I hope its contents will be clear and uncontroversial, and then we'll get it to you by the end of the day, next Friday.
That's perfectly satisfactory.
Thank you very much.
Thank you very much. Well, as I say, it only remains for me to thank Council for their helpful submissions in a complex case, and also to thank those behind who have assisted in the preparation for this appeal. We will, as you will expect, go away and think of how we resolve this problem. Thank you very much.